When we talk about the people judiciary, pro-society justice, pro-people judiciary or distributive justice, it is associated with utilitarianism. Assalamualaikum and very good morning to all of you. At the outset, please allow me to convey my sincerest gratitude and thanks to the organizer for having given me the opportunity to speak a few words before such an august gathering. At the same time, I have no hesitation to acknowledge that I am not the right person to address such a knowledgeable assembly of enlightened honorable judges of the highest courts, both from domestic and other South Asian jurisdictions. Also, I said the learned lawyers. But William Somerset Maugham wrote a short story, very funny short story, known the Luncheon. Somerset Maugham said that I did not have the capacity to go to a restaurant called Foyt's, where the French senator used to go and eat, but I went there to have a lunch date with a woman. I had only $80 for the entire month, and I spent all the entire 80 francs in the lunch. But at the end, we said that I was too young to have learned to say no to a woman. I am too humble to have learned to say no to a decision made by the honorable judges of the Apex Court. Ladies and gentlemen, when Mr. Justice Lobjang Rinjin mentioned the people's judiciary, what does it mean? All judiciary is meant for people, but when it is qualified with the word people judiciary, it signifies something different. What is the difference? In the past, judiciary mainly was engaged in corrective justice. This is a notion, this corrective justice associated with individual autonomy. It is recognized that laws are to protect the individual autonomy, and judges will give remedy in case of infraction of the law. So that's why judges look back at the past to identify the former position before the infringement of the law and restore the previous position, and also to determine the guilt of the person. That was the case. But when we talk about the people judiciary, pro-society justice, pro-people judiciary or distributive justice, it is associated with utilitarianism. The philosophy is that the mankind are in a community with common agenda, with common goal to maximize the common welfare for the community. So I give example how the people judiciary is shaping, reshaping and deshaping. In Victoria City of Canada, a group of homeless people, they started sleeping in the Victoria City Park. Then the city authority went to the court for permanent injunction that city park is not built for sleeping the homeless people, so we need permanent injunction. Then court said that, can you provide alternative accommodation? Then the city authority said that we do not have enough budget or enough space for alternative accommodation. Then court gave a very interesting judgment. Then court said that these homeless people will erect temporary houses in the form of tent from 7 p.m. to 7 a.m. That is, the homeless people are not evicted from the park. But had it been so 50 years back, 70 years back, you definitely would go for eviction of the people because park was not created, built for sleeping over there. Similarly, you look at this, how people's expectation went high because of this people judiciary. Eldridge versus British Columbia case. So for many centuries, there were people, so deaf and dumb people. They never thought that without a sign language interpreter in healthcare service, we are discriminated. But people's expectation went high. They started saying that if we are not provided with the resources as a interpreter, sign language interpreter, who understand our language as a deaf and dumb people will be discriminated. Then British Columbia Court decided that yes, the government must provide sign language interpreter to these deaf and dumb people, otherwise it will be discrimination. If we go to India, then we'll find that directive principle of state policy was right to education. This education in Unikrishan versus Andhra Pradesh case, the court said that it was promised in the constitution that after the journey of the constitution within 10 years, all the boys and girls below 14 years will be provided with free and compulsory education. But this Unikrishan challenged the capitation fee was very high for providing education. Then he challenged. The court said that after 44 years of the journey of the constitution, this directive principle of state policy is no longer directives. It is no longer unenforceable. It is a fundamental right. And Indian constitution was amended, and this right to education was incorporated as a fundamental right in the constitution. Similarly, if we go to Khet Muzdur Samiti case, if we go to the state of Bihar and Kopira Hingurani case, if we go, and finally another case I go to that People's Union Civil Liberties, people are dying because in want of food. Food was in the godown, but people were not given the food. Then the schemes, the charity schemes of the state, vulnerable group feeding, vulnerable group development, maternity scheme, old age pension scheme, all these things have been declared legally entitled. It is no longer the charity of the government. So that's why if anybody do not get 30 kg of rice at a price of 3 rupees per kg, then they can go to the court. So this is the way how the people judiciary. Then you go to the South Africa and find that there was a law. The law says that if a person takes loan and unable to pay the loan, then his or her house can be attached and sold out. Then court said that this law is a broad law because the main function of the state is to build or give houses, shelter to everybody. Here, this law is making the people who have home, making this law as a homeless people. So that's why they say that it is a broad law, that should be changed, and until or unless it is changed, it is the judiciary whose permission is necessary for attachment and selling out this house. So this is the case how we see that. Then if we come back here in Bangladesh, definitely, our judiciary is also playing very important role. In some aspects, I strongly believe that they are playing the role of transformative judiciary. Look at this. Once upon a time, there was a fire incidents in the garments industry. Almost every alternative there, we found that the fire accidents, people died burnt alive, or because of the stampede, narrow passage, they could not get out. So because of the stampede, people died. That it is because of the judgment of our apex court that you will find that no more fire accidents over there, no more people dying of stampede. Similarly, if you go to the case of the so-called OSD, Officer on Special Duty, I call it is not OSD, it is OND, Officer on No Duty, because they are not given any kind of duty. It is because of the judgment, because before this kind of judgment, it is that 5 years, even 10 years, people are in Officer on Special Duty. They did not have any duty. They come early in the morning and they go in the evening without doing anything and they draw the salary. They said that our court, honorable court said that no, it cannot continue because beyond 150 days, no one can be designated as Officer on Special Duty. So that's why if you go there, our court said that when personhood is given to the river, it means that river is not benefited. It is the people who are benefited because people in Bangladesh largely dependent on river, and one of the lifelines of the Bangladesh economy is river. So that's why when we are attributing personhood to the river, it means that we are a people judiciary, we are helping the people. So when I see that our court gives the judgment that so when the child is born out of rape, then in Allahabad court it was said that this child born out of rape will inherit from the assaulter. But our court said that it is too long to get the property after the death of the assaulter. Our court said that no. So child born out of rape will get the property during his lifetime, compulsory bequest by registered gift deed to this child who was born in out of rape. So if we go to Nepal, you find that in Shabda Pradhan Malla case, it is said that the Mulukiya and the National Court says that when wife is suffering incurably mad disease or incurably sexual disease, then husband has the opportunity to enter into second marriage. Then the Nepal Supreme Court said that, so this kind of thing is selfish on the part of the husband. When wife is in difficulty, in trouble, then husband is running away. This and any civilized nation can envisage this kind of law. So that's why I say that they did not declare this law ultra vires, but they instructed that law should be amended in line with the constitution of Nepal and also the Convention on Elimination of all sorts of discrimination against women. Similarly, in case of Mira Dungana case, it was said that husband was allowed to terminate the marriage if husband could prove that within 10 years from the marriage, it is because of the infertility of the wife, there was no child. So this law was challenged. Then the other party said that even wife can dissolve the marriage because of the impotency. The Nepal Supreme Court said that the lexical meaning of impotency and infertility is not the same thing. It is treated in different way. So that's why it is discrimination. This law was declared ultra vires. So this is the way the judiciary is working. But when we talk about the people judiciary, distributive justice, or pro-people judiciary, there are certain serious problems. These are common in all jurisdictions and something unique in Bangladesh. So what are the common thing is that Mr. Justice Lemar of the Chief Justice of Canada said that this sort of case somewhat like the spider web. When you pull on one strand of the web, the entire structure moves. But the entire structure does not move in the same direction. So it is very difficult to decide because it has a huge impact on the society, on the government, on the finance. So that's why they said that it is a very difficult issue. Similarly, when our judges are also doing, that's a difficult, very difficult issue. Other very important thing is that in our cases, our judiciary has serious constraint. Something as natural inherent and some other artificial. So one thing is that I found in a global report, judges and magistrates per million countries compared. In this title, I found that Russia has 468 judges for 1 million people. So European Union has 178 judges for 10 lakh people. Also the NATO countries had 182 judges. G7 nation has 106 judges. USA has 101 judges. Turkey has 93 judges. Qatar has 91 judges. Myanmar has 24 judges. Our neighboring country, India, has more than 20 judges per 1 million. But in Bangladesh, it is only 10 judges. So that's why it is something that it is very difficult to cope up with this situation because one hand is that cases are very difficult. On the other hand, that adversarial procedure. So it is one very important issue that we need to address. Other hand is that our judges are working in an environment which is unique from other nations. Sharply divided political nation, divided in the line of secularism and communalism. So when you work in this, it affects the lives of the people. It is very difficult. Then you are accused, you are blamed for certain results. So that is another issue, definitely. Another issue is that very peculiar issue. Some people say that this Bangladeshi nation, anthropologists says that the Bengali people are the hybrid nation, mixed nation, because the major groups, anthropological groups came to this Bengal. So Negris, Mongoloid, the Caucasian and the Australian, they came, some of them left, some of them residing. As a result, it has a serious impact on the behavior and lifestyle of the people. So as a result, we behave sometime in a way that there are certain protected person in the eye of law. In international law and also national law, they are protected person. They are immune from the jurisdiction of law. But we expect that many other persons who are not protected by the law, but still they should not be adjudicated. Even if they are adjudicated, then we become very, very aggrieved. that kind of attitude, but does not happen in other countries. So that's why I tell you that our judiciary is working with so many constraints, but despite the constraints, I strongly believe that we will overcome. We will overcome because it is the matter of justice. It is people judiciary. It is giving remedy to the people suffering humanity. We will definitely overcome. So thank you very much. Stay well, live well, keep well.